Major breaking news. The Donald Trump Bondi Department of Justice has just filed a major brief in support of the Second Amendment, fighting New Jersey's AR-15 semi-automatic rifle and magazine ban laws, a case that will be argued on October 15th of this year. Huge brief by the Department of Justice showing their support of our right to keep and bear arms. Major deal here. Let's break down this case and this brief when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, it's a huge deal here. It's further evidence, as I've discussed before, of the Department of Justice's support for the Second Amendment rights. Again, there's some people out there that are naysayers. They're really double downers, Debbie Downers, whatever you want to call them, when it comes to the Trump Department of Justice and the Second Amendment. I suspect most of those people that criticize the Department of Justice, overly so, for their Second Amendment positions are a little, shall we say, hyperbolic. Although I'm sympathetic to criticisms of this Department of Justice at the margins, there are mistakes that we all make. There are ways we can all improve, including the Trump Department of Justice under Bondi. There are ways to be improved. The reality is, overall, they're doing a fantastic job supporting, among other things, our right to keep and bear arms, and there's further powerful proof of this in the most hot topic, the most controversial, the biggest fight we have right now in the big picture of the Second Amendment. That is a fight over whether or not blue state jurisdictions and Chuck Schumer in the Congress can ban the most popular rifle in America, the AR-15, semi-automatic rifles and magazines that hold more than 10 rounds. Because remember, if the anti-gunners can ban magazines that hold more than 10 rounds, they can certainly ban magazines that hold more than 7 rounds or more than 5 rounds or more than 1 round possibly. So we need to win these cases, and we need to win them big, and then we ultimately need to win them very soon before the United States Supreme Court. And I'm happy to report that the United States Department of Justice, under Donald Trump and Bondi, Harmeet Dillon, and Jason Mannion, who are the people that submitted this brief, are fighting for our rights. It is very obvious if you read this brief submitted in the United States Court of Appeals for the Third Circuit overseeing New Jersey, Delaware, and Pennsylvania, in this case arising from New Jersey, because remember, New Jersey essentially has bans on AR-15s, a bunch of semi-automatic rifles, and magazines that hold more than 10 rounds. This case as to whether or not that's constitutional will be heard by an en banc Third Circuit, which means every single active judge on the Third Circuit Court of Appeals is going to hear this case being argued on October 15th of this year. Well, the Department of Justice has just filed a major brief completely siding with the plaintiffs in these consolidated cases of Cheeseman and the Association of New Jersey Rifle and Pistol Clubs. This is a big deal, folks. This is a similar brief, but in some ways a stronger brief than even the brief we saw the Department of Justice file in the Barnett case in the U.S. Court of Appeals for the Seventh Circuit, which, by the way, is being argued next week in Chicago. Specifically, the Department of Justice is arguing that they have a duty to protect the Second Amendment, that both Bondi and Donald Trump by name have instructed this administration to protect the Second Amendment rights of all Americans and to use the Department of Justice, its full might, the full might of the Department of Justice to protect the Second Amendment rights of law-abiding citizens. That is exactly what Attorney General Bondi has instructed the entire Department of Justice to do. And it is pretty clear that Harmeet Dillon and Jason Mannion and the other people in the Department of Justice are doing exactly that. Specifically, if you look at this brief, which I'll put a link to it down below, they argue specifically that the Second Amendment protects all arms that are in common use, which of course is something you've learned about repeatedly on this channel. That if you have an arm that's in common use by Americans for lawful purposes, it cannot be banned. That is very clear. And they also point out that some of the reasons why one might own these guns is not only for self-defense, it's not only for hunting, it's not only for plinking, but it's also for the common defense. Because remember, if you read the entire text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed is the operative clause. But you also have the prefatory clause, dealing with a well-regulated militia being necessary for the security of the free state, or a free state. And what that's talking about is, if you want to make sure you have a free country, you need a well-regulated militia which consists of all the people, basically. You need an armed citizenry. Keep in mind, before the founders wrote the Second Amendment, they studied thousands and thousands of years of history and governments that had risen and governments that had fallen, countries that have succeeded and countries that have failed. And they found that the right to keep and bear arms among the people was mission critical to demonstrate that the government trusted the people. The government trusted the people to be sovereign. Because never forget, folks, the deep state is not sovereign. The federal government is not sovereign. The president is not sovereign. We, the people, are sovereign. We grant some of our rights to the government for the good of the order, for the common defense, for the common good. But the powers that they wield come from we, the people. And if you cannot trust we, the people, with arms, you're not trusting we, the people, with anything else, which is why the Four Boxes Diner is named after the four boxes of American liberty, which includes the right to bear arms, which is the cartridge box, in addition to the right to vote, which of course is the ballot box, the right to a rule of law, which is the jury box, and of course the right to free speech, which is the soap box. Those are the four boxes of American liberty. By extension, the name of this channel, the Four Boxes Diner. The diner refers to casual conversation and Mark not in a suit. Okay, with that said, let's go back to this major brief submitted by the Department of Justice, where they continue to fight for all of those rights that we, the people, want protected, including the right to keep and bear arms. But one of the things that ties into this militia point is that they talk about the importance of these arms for the common defense, which ties into the prefatory clause of you need a well-regulated militia and armed population to ensure the security of a free state. And this brief by the Department of Justice makes that exact point, saying that by having these commonly owned firearms protected under the Second Amendment, that is totally appropriate because, among other things, in addition to having the right to bear arms for the purposes of hunting, for planking, for the purposes of training, for the purposes of self-defense, you also need them for the common defense, to tie that back into the prefatory militia clause. That's a point well made by this brief and the Department of Justice. Beyond this, they also defend the in common use test. As we've explained, there is, just to jog your memory, the way you do a Second Amendment analysis, which starts really in Heller, and Bruin is nothing more than an extension of Heller. Bruin and Heller are the same case when it comes to the methodology. The only difference is they spelled it out in more simple terms in Bruin so that lower court, inferior court judges could really follow the dots, because they were not doing so because they obviously could not read effectively when they read the Heller decision. So to fix the mistakes made by the lower courts, the Bruin decision reiterated Heller. But never forget that Heller and Bruin are the same methodology, which means you start with the text of the Second Amendment, which is an unqualified command. The right of the people to keep and bear arms shall not be infringed. If a modern-day gun control law implicates that text, if the activity that you want to engage in as American citizens somehow is implicated by the plain text or covered by the plain text, the law that restricts you, burdens you, is presumptively unconstitutional. And then that shifts, of course, to the government to see if they can establish and meet their burden to show there's a long-standing, well-represented historical tradition of some sort of firearms regulation that is analogous to the modern-day gun control law, to justify that, to show that this modern-day gun control law is really an extension, if you will, of long-standing, well-representative historical traditions of firearm regulations in this country. And that is exactly what this in common use test arises from. Because as this brief by the Department of Justice points out, and one of the big things I think this Department of Justice brief does, as an amicus in support of the Second Amendment proponents in that Cheeseman case, and the Association of New Jersey Rifle and Pistol Clubs case, consolidated there in the Third Circuit to be argued on October 15th. One of the big things I think this brief does that's very helpful is they really go through and justify in law the in common use test. Because remember how I pointed out earlier in this video that we, the people, are the sovereign, and we give up some of our authority to the government for the good of the order and for the common good? Remember I explained that to you? Why is that important? How does that tie into the in common use test? How exactly does we, the people, being sovereign, tie into the in common use test, you might ask? Well, it ties in quite nicely. And the Department of Justice basically makes this point. They point out that going all the way back to England, it was expected of the populace the population, they would own common arms at various points. And in American history, at the start of our founding, it was understood that Americans would own common arms. Those common arms are to be distinguished from crazy, unusual, and weird and extra dangerous weapons of some sort that might scare or terrorize the people. So they draw this nice distinction between the history of ordinary Englishmen and then ordinary Americans owning commonly owned arms, whether it be swords at one point, maybe bows and arrows at another point, and in American history, of course, firearms, cartridges, and the like, all of which, by the way, as you know, in the Militia Act of 1792, people were actually required to own these weapons, these common weapons, to bring them to militia musters under the Federal Militia Act of 1792, which recognized that all Americans had these commonly owned arms. The reason why that ties into American sovereignty now is this. Who decides what is a commonly owned arm? How does something become a commonly owned arm? How does some arm or weapon become ubiquitous in American society? Is a law passed that says you must buy a rifle made by the Four Boxes Diner that's blue or green? No. That's not how an arm, that's not how a gun, that's not how a type of ammunition becomes popular or in common use in America. The way a weapon becomes in common use in the United States, and this has been true since before we were a country, before the 1791 Second Amendment was even adopted. We, the people, decide what arms we want, what bearable arms we want. We decide what weapons we want. We are the determiners of what weapons the American people buy. We are the American people. And as Heller pointed out when it pointed out that handguns could not be banned in the Heller case, and the Supreme Court pointed out that handguns, for whatever the reason it said, handguns are obviously the preferred choice for self-defense by Americans all across this great country, and therefore it cannot be banned. Heller specifically says you cannot ban handguns. The government cannot ban handguns because they're in common use as determined by we, the people. We made them in common use. We made them common. We made them ubiquitous for self-defense because we went out and bought them with our hard-earned money. So too, this Department of Justice points out that AR-15s and magazines, of which they point out, there's orders of magnitude more magazines that hold more than 10 rounds, 100 to somewhere between 100 million to 500 million of these magazines that hold more than 10 rounds. Sometimes I wonder if I have half of them. I'm sure many of you have the same feeling sometimes too. But the reality is that magazines that hold more than 10 rounds are even more popular than semi-automatic rifles. There are more magazines than rifles in this great country. And how did that come about? Did Gavin Newsom make us go out and buy semi-automatic rifles? Did Gavin Newsom make us go out and buy AR-15s? Did Gavin Newsom make us buy, by statute, these magazines that hold more than 10 rounds? No. We, the people, the sovereign, made the decision to go out with our hard-earned money and acquire these items. And by extension, that is how they became common. They became in common use in America because we, the people, chose these types of weapons to own for lawful purposes because we preferred them. We chose them. And that is exactly what the Department of Justice is essentially arguing here. That there's Supreme Court precedent going back to the 1930s with the United States versus Miller case that points out that going all the way back to the founding, arms that were typically possessed by Americans for lawful purposes are protected. That's what used for the militia. That's what was brought to militia musters. Heller, the same thing. In common use. If it's in common use, it cannot be banned. Handguns were in common use under Heller and could not be banned. And of course, that extends, as I explained, the flip side is, from the perspective of what the government has to prove in a world, if they try to ban a gun, like the machine guns, let's say. I know we've had this discussion before about the political realities of machine guns, but let's just take that as an example here. The government would argue, they're not arguing it so much here, but the government would argue that machine guns can be banned under the dangerous and unusual standard, pointing out that the dangerous and unusual standard is the historical tradition of firearms regulation that does exist. So again, unless something is dangerous and unusual, And whatever you want to argue is the meaning of dangerous and unusual. An arm that is in common use cannot be dangerous and unusual because it cannot be unusual. And here the Department of Justice under Trump and Bondi are specifically arguing that AR-15 semi-automatic rifles and these magazines cannot possibly be dangerous and unusual because they are in common use by Americans for lawful purposes, including but not limited to for self-defense and the common defense. So this is another very powerful brief on support of the Second Amendment by the Department of Justice. I urge you to read it. There's a lot of good nuggets in here, but I'm happy to report as a general matter, this is a very consistent set of arguments with the sort of things I've taught you here in the Four Boxes Diner. So I'm happy to report that what you're learning here on the Four Boxes Diner, you could go into court and argue this stuff and use this stuff because it's pretty clear that the Department of Justice of the United States of America are making similar arguments. So I think we're on the right path on this channel and kind of educating you as to the best way to argue these cases in the real world. So to close, let me just read a little part of the brief to give you a taste of the arguments made by the Department of Justice. Check it out. New Jersey's complete bans on possessing rifles such as the AR-15 and magazines with more than 10-round capacity violate the Second Amendment. Because rifles such as the AR-15 are in common use for lawful purposes, including self-defense, sporting, and common defense, the Second Amendment protects law-abiding New Jerseyans' right to possess them. The Second Amendment also protects those New Jerseyans' right to possess magazines and other accessories that make constitutionally protected firearms useful for those same lawful purposes. This court must make clear that the Second Amendment does not allow New Jersey to ban the most popular rifle in America, nor does it allow New Jersey to ban more than 10-round magazines, which are significantly more popular than AR-15s themselves. All right, so great news out of the state of New Jersey, the Third Circuit, a powerful brief by the Department of Justice and reaffirmation that whatever you want to say about Pam Bondi and Donald Trump and the Second Amendment, the proof is in the pudding. And again, no one is perfect. No one gets everything right, except, of course, we hope at the Four Boxes Diner. But the reality is the Department of Justice is doing a fantastic job defending our rights. Are they perfect? No, they're not perfect. They're in a swamp, right? They're in a terrible swamp surrounded by swamp creatures. So it's hard to get everything right at all times in this environment. But we have to say, if we win the AR-15 case and the magazine case, that is a huge victory for the right to keep and bear arms all across this great country. So there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at Four Boxes Diner. Don't forget to like and subscribe to the video, both on Rumble and on YouTube. And I look forward to talking again real soon here at the Four Boxes Diner.
Orders up. Table 2A.